This is in reference to criminalisation of Indian polity. Honorable Supreme Court, while hearing a petition, in reference to criminalisation of Indian politics, while hearing to the argument of Election Commission of India, has opined that something strongly needs to be done to prevent persons with criminal background to participate in the elections. Now, such opinion has already been given by the Honorable Supreme Court a couple of times in the past, but nothing much has happened. Nothing is actioned as such. If you see the last general elections, 40%, survey says that 40% of the public representatives who contested the elections or even won the elections have one or the other type of criminal background. Now, such is the situation. Just 40% is a very big area. Almost near to half of the candidates who contested and who have managed to win the elections have one or the other type of criminal background. Now it must be discussed whether participation of people with criminal background is constitutional or not. Our constitution is very clear that an accused person of a crime, however grievous, however serious the nature may be, it may be rape, it may be creating enmity between the religion, between the people, between the sections, or it can be promotion of hatred, and it may be division of it may be attempt and acts to divide the people on language fanatic grounds. So whether people who are involved but not convicted, is there a provision to stop them from contesting elections? So as per law, there is no bar according to me, because until unless there is a conviction, that he is involved in a criminal act, until unless it is confirmed, nothing in law can stop him from contesting the elections, because our system believes that until unless he is proven guilty, he must not be. He is only an accused. He is not a convict. So therefore, all rights which is available to the people will be available to them also. So therefore, in this situation, what can we do to end this, this issue? Criminalization of politics is one of the serious issues that is haunting and destroying the democracy day by day in India. So what can be done? So the only solution that is possible is trial of the cases, criminal cases, should be done on a fast track. It must be decided within 6 months to 1 year. In fact, there was a proposal. Now it looks to be dumped, at least for time being. See, whichever the public representative or a political representative who wants to contest the elections, if he is accused of any criminal, accusations involving heinous crimes, at least, he must be tried and the law must settle in reference to his crime within a tenure of 6 months to 1 year. So in this way, once he is convicted, then there can be a law application of law. He can be prevented from contesting the elections. So just speaking in the judicial platform, expressing concerns, or the members of legislative, Prime Minister, Home Minister, or people of the public representatives who hold important positions, when they make statements, that doesn't hold good. That doesn't bring in any reform in elections. So in Representation of People's Act, Section 8/1 actually forbids people, whoever create enmity between the religion, whoever uses the religion, caste, language, Section 153A IPC deals with that. They can be prevented from contesting. But the question is whether the accused person, an accused person who is involved in such crimes, can he be prevented? He cannot be prevented. So until unless the party takes an issue, the party, if he is accused of a corruption or if he is accused of crimes which is dividing the society, creating a divide and hatred amongst the society, such crimes, even though he is an accused, if the party takes this stand, then it is possible. By law, it is not possible until unless he is convicted. So the only possibility is the trial should be on fast track. There must be special courts that must be created for trial of these public representatives, the leaders who contest the elections, who have criminal background. So they must be tried fast and the case must be decided within the shortest possible of time, that is 6 months to 1 year. Only then by law the public representatives who have got criminal background, who are convicted, can be stopped from contesting the elections. Otherwise, the entire responsibility of the accused falls on the political parties. They die hard take any responsibility. They look at the winning preposition. They look at the winning combination, winning capacity of the candidate. They are not looking at the criminal background, whether he is accused of what crime. That doesn't come there at all, because they want to win the elections. So this way, whether it is judiciary or whether it is members holding top positions in the union government, just making statements in the public platform or judicial platform, stating that there is a criminalization of politics is taking place and something needs to be done. So nothing can be done until unless trial of such accused person takes place on a fast track. Only that can bring in a solution.